You were hiding, Paul, so I couldn't find you, so I didn't know where.
I'm also the adoptive mother of a child with trisomy 21, and so reading your story in Life News meant a whole lot to me. It made me take a much closer look at your campaign, to be quite frank with you. And but I also, and I would love to hear just how Bella's doing.
Bella's doing great. That's Bella right down there. Bella's 3.5. She's trisomy 18.
I know that.
And just trisomy 21 is Down syndrome, and trisomy 18 is something called Edgeworth syndrome, and they're similar in the sense it's an extra chromosome. You're supposed to have 2 chromosomes, and so they're different numbered pairs of chromosomes. And in Down syndrome case, the child is born with an extra 21st. In the Edgeworth syndrome, trisomy 18, it's an extra 18th, and there are very different problems associated with each one of these genetic disorders, and so we sort of feel like we're in the trisomy family of all of these children who are little angels and blessings for us in the world to appreciate the special gifts they are. I remember going to one event with a Down syndrome little girl, and she said, I have an extra chromosome, and she called it the love chromosome.
Yeah, there's an awful lot of joy in that extra chromosome.
Really, it's amazing.
My question for you, my audience in particular, asked me if I would ask you, the National Defense Authorization Act has a component in it that it has frightened a lot of people, where it looks like, if you're just reading it as a press person like me, layman, yes, thank you, that it gives the president some sort of authority to detain a citizen or a legal alien, a legal immigrant with absolutely no just cause, just basically national interest, not even national security, not even threat, just national interest. I'd love your comment on that, and is that something that you would work to remove from the NDAA? Thank you.
What I've said repeatedly is that the law, that this bill should not change what the law was prior to the bill. Everyone I've talked to, and I've talked to some members of the Senate who were involved in this, they said, look, our intention was,
let me give you the shot,
and then they went on, that to codify what the case law is in this area. And the case law in this area is that a United States citizen who is detained because of a national security risk is entitled to what any citizen who is arrested is entitled to, which is a hearing, a habeas corpus petition, a hearing before a federal court, and if you're detained by the federal government. And so what this bill was, again, intended to do was create a statutory, in a sense, so the court couldn't change it. They wanted to create a statutory provision that said that if you're detained by the United States government for concern about national security or risk of national security, that you have a petition. You can petition the federal court, a habeas corpus petition, to the federal court, and be provided counsel. And at that petition, at that hearing, that a judge, a federal judge, has to, by a preponderance of the evidence, find that this is a legitimate detention, that you are in fact a risk to the country. And if a federal court finds that, then they can detain you. If they don't, then you have to be released. And so the key here is that there's a judicial proceeding and that the facts are laid out and you have an opportunity to make your case.